The member for Albany.
Thank you. Today I'm proud to rise as a Member of Parliament and as a woman to speak in support of this very important piece of legislation, the Abortion Legislation Reform Bill. I know how much this legislation will mean to my constituents, the women of Albany who rely upon the provision of safe and effective healthcare services. I have listened with interest and, like many other members in this chamber, have heard heartbreaking stories shared by many members who have reflected on personal stories from people in their communities. This bill will help women access appropriate health in a timely and effective manner, something that is still not always possible for those living in regional and remote areas. While my electorate of Albany is now a bustling and vibrant regional city, we are still 4.5 hours away from Perth by road, and while we have regional airlines, airfares are sometimes out of reach for some. The proposed legislation changes will help ease the path for women walking that can be a difficult road towards accessing abortion healthcare. Not only will this legislation bring us in line with other Australian jurisdictions, but it will provide a more level playing field for regional, remote and country women by removing unnecessary barriers to accessing healthcare. We know that the earlier a woman has an abortion, the rate of complication is lower. We also know that many small regional towns only have one doctor at most. Some of these small towns have no doctors. Some travel for healthcare services sometimes necessary. To find one doctor to sign off on abortion healthcare in a small town might be difficult, but to find 2 practitioners to do so is currently impossible for many. So to remove the requirement of 2 practitioners to be involved in the decision about abortion will have a measurable benefit impact on women living in the country. This amendment alone removes an unnecessary and unhelpful barrier in healthcare. Removing barriers. To expect a woman to receive counselling prior to accessing an abortion is to treat her like a child who cannot make a decision for herself. Women, we know our bodies, women have agency, and we can make our own decisions in our own best interests. Provisions in the Health Miscellaneous Provisions Act requiring patients to receive counselling in order to provide informed consent to an abortion does not reflect contemporary thinking, practices or expectations. In what other scenarios do we demand that patients are consulted prior to accessing legal healthcare? Requiring counselling prior to an abortion is an outdated expectation that does not belong in this modern world. When this government removed the right to protest outside abortion clinics in 2021, we removed one barrier preventing women accessing healthcare, protecting them from harassment and intimidation within 150 metres of the abortion services. As a consequence of that change, women and girls no longer have to run the gauntlet of abusive activists outside abortion services. That was one positive step forward. But I remember the stigma that was attached to abortion when I was younger. In some places, that stigma still exists. I remember how in a country town, word got around when a young woman needed to access an abortion. I remember thinking how difficult their experience must be. I remember wondering just how a young woman would take those steps if she was not living in a city with the access to a range of health practitioners and confidential treatment. So, how did she do it? With great difficulty and at great expense financially and emotionally. Sometimes she didn't manage to do so. Some women passed the gestational limit because it was too hard for them in a small town many hundreds of kilometres from Perth to find someone to sign off on their own decision about their own body, about their own future. The changes proposed in this legislation will go one step further than the Safe Access Zones legislation by providing compassionate access to abortion that better reflects contemporary clinical practice. I applaud this legislation as historic, as necessary and as progressive. The current legislation framework in place does not provide guidance to or place obligation on medical practitioners who refuse to participate in abortion care for contentious objection reasons or otherwise. I'm particularly pleased to see that this is addressed in the Abortion Legislation Reform Bill. Current Currently, a patient whose GP refuses to participate in their abortion care may find themselves required to see several medical practitioners before they find one willing and able to participate in their abortion care. This is unacceptable. This bill clarifies that both medical practitioners and students may refuse to participate in an abortion. However, in this event that a medical practitioner refuses to participate in an abortion, they must immediately disclose their objection to the patient. Practitioners are then obligated to transfer the patient to a registered health facility that they believe can provide abortion services, or that they must provide approved information to enable the patient to access treatment elsewhere. This gives respect to women seeking an abortion and provides her with a pathway forward to seek the medical care she requires. If 1 in 5 or 1 in 6 women in Australia have an abortion, then this legislation will help many, many thousands of women in Western Australia. This is what we are here for in this place, to help people. So I thank the Minister for Health and her department and their staff for their hard work on the abortion legislation reform, and I thank the House for the opportunity to speak about this important bill and to promote to you all as an essential step forward in the healthcare for women. I applaud this step forward for women's productive rights. I thank all the practitioners who have worked under a challenging framework and all the while making sure that women have had access to safe abortion healthcare. And I thank all the countless women and dedicated service providers who have had input into framing of this legislation. Abortion is legal, but it is essential that abortion services are fit for purpose, safe and accessible. Through the consultation process and in the framing of this legislation, the views of all women and all practitioners who have had input has been made it paramount. This legislation will move West Australia from a position of having restrictive abortion laws regulated under the criminal code that took decisions about women's health out of the women's hands, to a position where our laws will be fit for purpose as a fundamental part of this modern women's health service landscape. It is essential that all women have access to safe abortion in WA, and this legislation will enshrine that right in law. Thank you.